Our tutor is with us, of course. Ansel, can you hear me?
Good evening.
Yes, yes. So please proceed.
Thank you.
And thank you very much.
Thank you. Good evening, guys. I hope your week has been good. I know that there are, of course, ups and downs, if not ups, but you're having issues with sleep, obviously, because you don't want to be the one who's late. And I just hope it's going well. I hope everything is kind on you, and I also hope you're kind to yourself, as I said during the professional ethics discussion. So first things first, I must tell you that trial advocacy is where you score free marks. You will rarely get a receipt for this unit because it's quite self-explanatory. But for the purpose of answering the exam questions, let's just go through it. I do not ever have notes for trial advocacy because I rely on my notes when I was doing the ATP program. What I want to tell you to do is maybe get a piece of paper and write short notes, or just type from the comfort of your phone or laptop, whatever it is. But for now, we already established that writing with a pen makes it relievable tomorrow. Tomorrow, you're able to know what you wrote at a particular point, especially when you need to write a lot of points at the same time. All right. So let's just start. What is trial advocacy? Of course, this is the practice. It is the practice that you're being taught right now. Everything you're learning in the other 8 units is trial advocacy. But for the most part, it takes place in a court proceeding. Okay. It takes place in a court proceeding by advocates. So you as an advocate, what you're learning now is how to present yourself in court, okay? So you're going to be required to have tactical skills. These are individual skills, okay? Are you able to move the court? Do you have a personality? It boils down to personality. Also, do you have emotional intelligence in case anything goes wrong? Okay, because a lot of things can go wrong in the court, okay? So you need a personality, you need emotional intelligence, you need tactical skills. You must be able to know when to talk to the people in court, when to appear like you're seeking the empathy of the court. You have to know how to give opening remarks and then closing remarks. And then in the middle, right there, you're supposed to be present. You're supposed to be able to present yourself well. Normally, you will find yourself doing maybe examination in chief, cross-examination, finding yourself through the process, okay? Because if you're going to be the one doing examination in chief, then it means you're not doing the cross-examination. You will do re-examination. Do you have the tactics for that? Do you have a strategy? What is your strategy, okay? And then, are you abiding by the principle of professional ethics or the principle of law, or even just human principles? Are you human in court? Are you able to say, this is not going my way, I'm just going to take the high road? Or will you show, we call it thorax, like you're trying to fight the others in court, okay? So trial advocacy is basically that. It gives you a way of presenting yourself against a forum, okay? And you're able to tell other people's stories in a professional way, and then also in a personal way, using the skills and training that you've acquired over the years. And when we talk about trial advocacy, let's talk about the premises. And the premises is the Constitution, okay? The Constitution, sovereign power belongs to the people, okay? But this power will be delegated through, of course, there's parliament, okay, and national assemblies in county government, and then there will be the national executive, and then there will be the judiciary and independent tribunals. So you will stand before a judiciary and independent tribunal most of these times, and we are thinking here of the overriding objective, of course. Just think of Article 159 in its entirety, okay? Number one, we'll think about a judicial authority being derived from the people, okay? And it shall be exercised in courts and tribunals. We'll think about overriding objective, Article 159 2D, where no suit shall be defeated because of technical issues, and there you are ensuring that the suit is not defeated, okay? And then, of course, tribunals is Article 168 of the Constitution, okay? So in Kenya, as an introduction, we have we abide our court system. Our court system is the common law. Okay, so why is it called the common law? Because we tend to use judicial precedents. Okay, we use case laws. Have you read rulings? Have you read judgments? Have you read petitions? You will see that they are very rich in case laws. We use judicial precedents. Why do we do that? Because we, as a colony of the UK, we adopted a system of common law. Okay, what is another thing we do that makes us a common law? Our systems are very adversarial in nature. Our systems are very adversarial in nature, in the sense that we will have a judge or a magistrate or whoever is presiding tribunal. We will have them in the middle, taking a very neutral stance. But then we will have opposing sides. Okay, we will have the plaintiff and the defendant. Okay, we'll have the complainant and the respondent. We will have the claimant and the respondent. We will have the applicant and the respondent. It is always opposing parties. It's like they're fighting. Okay, so we use the word adversarial. Our courts are adversarial in nature, unlike places like France and the US, where the system is called civil or continental law system. Okay, them a lot of things are codified for them. Everything they do abides in the law, and then they are not necessarily adversarial, because we have a judge in the middle. The judge will do the investigation. They will ask questions. Okay, so their system of law is codified. It is called inquisitorial. Okay, so ours is adversarial. I'm building a premise where, when we move on, you already know where we've started. Okay, so why is trial advocacy very important? The fact that we have an adversarial system means that we need to create a balance. We need to create a balance, and then we need to have a decorum on how to behave in court. So very quickly, I think I want to skip the history of common law, because it will not help us. So what are some of the features of common law? We have issues like ratio decidendi. Okay, ratio decidendi. We have reasons for the court deciding, making a certain decision. We have obiter dicta. Sometimes the judges will pronounce themselves while giving judgment, but these are not to be followed. They are not ratio decidendi. They're just persuasive. They're saying maybe we should do this, maybe we should adopt this system. Okay, and then of course we talked about judicial president, or we can call it stare decisis, which is let the decision stand. So if you've read the history, of law, which I said I will not talk about law in England, it used to be benches where the king would send people, and people would adjudicate. They would adjudicate on cases, and then they'll say, this is the reason why we are making this decision. This is the ratio decidendi, and so this decision will stand. And the fact that that decision stands at that moment, it means that any other case that will be brought forth that has similar facts, okay, that has similar facts and similar issues, they will apply this law. They will apply this law. And that is how we have inherited case laws over and over and over again. And that is why we have picked on or abided by the decisions of the Supreme Court. Okay. So by now, you know what a president is, you know what or you can call it precedent. We know what an obiter dicta is, and obiter dicta, you can just call it by the way, okay? And then we have a ratio decidendi, let the decision stand. So what types of legal precedents do we have? We have a binding precedent. This is mandatory, okay? This is mandatory, and it has to be followed by all subordinate courts. So the Supreme Court will make a binding precedent, and it will be followed by other courts. Okay, which other precedent do we have? We have the persuasive. A court may rely on a persuasive precedent, but you're not required to rely on them, e.g. a case law. Okay, an example of persuasive I'll find an example of a persuasive case law. Let's continue with another precedent. We have original precedent. Okay, original precedent. If you've seen Solomon versus Solomon, the one for company law, you will know that it is an original precedent. Because before that, corporates were never striped off their corporate veil. Okay, the corporate shell had not been cracked for people to be identified away from the corporate veil, okay? Also, the SM Otieno case, the SM Otieno case is a succession case. That is an original president. This is the first time there was a clash between the Judicature Act and the laws of, the laws of Kenya. Let me say the constitution at that time, okay? At that time, or the Law of Succession Act. There was a clash because Wamboi kept saying Otieno had changed. He wasn't following the Luo way of life. I want to bury him in Matasi Angong. And the people kept saying every weekend, or at least, once a fortnight, when someone dies in our village, Otieno boards the plane from Nairobi to Kisumu, and he comes to bury our people according to the Luo custom. So we have to bury Otieno in Nyalgunga. So that's an original president, okay? We also have declaratory presidents. These ones, they already exist and they are applied in identical cases. The court will just say, we will go by that case that once existed. So we have binding presidents, persuasive, and then we have original, and then we have declaratory presidents, okay? Now, let's look at we've talked about inquisitorial and adversarial, and we've said that ours is it's more of an adversarial system, okay? So in your syllabus, I'm just mentioning because it is in your syllabus, you will find sometimes you may be asked the difference between adversarial and inquisitorial, okay? And you'll say adversarial is for common law countries, as we have said, two advocates or two opposing parties, okay? Because sometimes parties will not have advocates. They will go to court by themselves, okay? And inquisitorial, we have said court is actively involved in the investigation. This is a civil law system. There is extensive investigation by the court, okay? And it is more vertical, okay? It is more vertical. You will find differences, and that is what you will say. And let's look at the next topic, which is lawyers hired guns, okay? Because lawyers have been called hired guns. And if you know the story of hired guns, these are usually experts, okay? These are experts, and they're experts in their field. So what they're done for is they're given tasks. They are told, we want you to take down someone, okay? So people are saying these lawyers, see, they are hired guns because they are hired to bring down people in a case. But this argument is twofold, okay? Some people will say a lawyer cannot be a hired gun, okay, because he's skilled in what he does. He is within a profession, and he abides by certain laws. So this is more of this guy is in a profession, okay? He is not a hired gun. A hired gun is more of the street guy, the guy you send to the street, okay? And the argument is well received on both sides. Some people will argue and say this is a hired gun because what they are saying is you may get to my client, but you have to come through me first. So if you're asked of such a question, give it a twofold approach. The one say no, they are not hired guns because hired guns are just, they kill on behalf of another, okay? But a lawyer goes through the process of preparing, researching after being instructed. They research, they send demand letters, they send legal opinions, they go to court, they make submissions, they do the examination process. After that, they ensure that they've really, even if it is an appeal, they take the client to the appeal stage, further appeal, okay? But for guns for hire, it's just, you have a gun, your feet, you've been trained in your field, go out there and kill that person, okay? So what are the roles of lawyers in a society? What are the roles of lawyers in a society? And the first thing you must think of is public interest, okay? You're very responsible in the front of public interest. What is another role? You're supposed to promote justice and uphold the rule of law. Your sopek, fikiria tu your sopek vile inasema, okay? Under public interest, you can say issues like the legal week, where lawyers go to, the legal week, and then also think of Section 55 of the Advocates Act, where lawyers and advocates are officers of the court, and they shall be subject to the jurisdiction of the disciplinary tribunal if they are found to be in misconduct, okay, or unprofessional conduct. So you're law in the society, remember section 55, remember SOPEC, and you know that you're required by the overriding objective to ensure that the court process is efficient and it's fast, okay? You're not supposed to be delaying cases. You should expedite court proceedings. You enhance respect for the court. You're supposed to obey court orders and instructions as laid down. You're supposed to correct the court, but nicely, okay? There, correct the court nicely with respect accordingly, okay? And you're not supposed to influence court or court officials in a manner prohibited by law. Of course, act in a professional manner, be punctual. Trial advocacy, it starts in the morning when you get into court. If you are late in court, you're supposed to apologize for your lateness or notify the court in advance, okay? Tell them you will be late so that they can push your file. They have a system. Court has a system. By the way, lawyers and magistrates and judges work very well together if you've been in a court setup, okay? They push the file behind, and then at some point, if it's the only file remaining, you will see the presiding officer or the magistrate telling the clerk, how far is this person? Are they able to make it? And you will see some calls or texts being made. So it's a system of just respecting each other and working together mutually, okay? They might appear like opposing sides to you in court, but when the real relationship is revealed, this is it, okay? So what are your other roles? You're supposed to be courteous. You see, this is more like general knowledge. You're supposed to act in good faith. Any promises that you made, ensure that you see them through, okay? You endeavor to communicate early with the other counsel. You can tell the other counsel, I'm caught up, okay? Serve the counsel early. See at that morning of the court, and you're rushing pleadings to the counsel. Also, try not to seek unfair advantage over the other person or the other party, okay? And then do not delay court procedures that you're just seeking for extra time kila siku. You're always making applications for postponements, okay? You may be viewed as someone who's trying to obstruct the case or the cause of justice, okay? And then uphold confidentiality. I told you, do not say confidentiality is Advocates Act Section 134 and 137. It is the Evidence Act. I hope you remember that. Uphold fidelity. Be honest, okay? Protect the client's interest. Avoid conflict of interest. Take and follow proper instructions. Adequately advise the client. You see, these ones are no-brainers. These ones will just work so well for you if you're asked these questions, okay? And then, of course, we've talked about keeping the client updated, and then zealously represent the client. So the question is, can we advocates defend bad guys or bad people? And then you will answer and say, how does the law know that this person is bad if they've not been taken through the due process of law, okay? So here we are talking about fair trial and beyond reasonable doubt for criminal cases. So unless the person has been taken through the due process of law, then someone should not tell you at you lawyers defend bad people, okay? And we should not join society in condemning a person. You take a neutral stance and say until a judgment has been passed, then this person is innocent until proven guilty, okay? And I'll give you an example with the case of Philip Onyancha. Philip Onyancha, a few years ago, was out there. People were saying he's a cannibal. He was eating girls. He was luring ladies in the pretense of, come, I take you out, come visit me, and then he would eat their flesh. So when Onyancha was taken before Justice Lesit, people refused, lawyers refused to represent him. No one wanted to represent him. And you see, this is one of those cases where we have to have a pro bono advocate, okay? So there is a lady who came forth and just said, I will represent Onyancha. And in his, remarks, Justice Lesit really applauded the lady, saying no one should be judged or condemned unheard, okay? So that is part of also your role as a lawyer. So let's look at the role of lawyers and the UN basic principles on role of lawyers. If you are told to compare, if you hear me saying if you are told to compare, it's because I've perused the question papers just this afternoon. And so I'm applying the question papers to the syllabus, okay? If you're told to compare UN basic principles of lawyers versus the laws in Kenya, then here is what you do, okay? These principles, they were enacted. They were enacted in 1990, okay? They were adopted in 1990 by the UN, okay? So there was this conference where the UN Assembly adopted them, and the idea was to find principles that lawyers can abide by that will not take away from the right of lawyers, but at the same time, they will be like a yardstick to how they conduct themselves. And they were premised on a lot of conventions and declaration, like the Universal Declaration of Human Rights, UDHHR, and of course the ICCPR, that is the International Convention on Civil and Political Rights, okay? So some of those, they were premised under some of those. And what were they trying to prevent? They were trying to prevent abuse of powers by you, lawyers, okay? And then adequate protection for you. And then they were also setting up a standard where jurisdictions that do not have associations can form professional associations that will help them to create standards and ethics that will protect them from prosecution, okay? And infringements. Of course, you know, the society we live in, a lot can happen in a very short time. So what we have SOPEC, and then we have Advocates Act, and we have those marketing rules and etc. Advocate practice rules, which have borrowed from the UN Basic Principle for Lawyers. If they didn't exist, they have borrowed heavily. But if they already existed, then they are also in tandem, okay? They are also in tandem with the US principles for UN principles on the role of lawyers, okay? So the first one is access to lawyers and legal services, because it caters for people during this Congress. During this Congress, it was about prevention of crime and the treatment of offenders, okay? So when they were setting these rules for lawyers, they were thinking, number one, let's cater first to these people who are caught up in crime, okay, people in conflict with the law. So the first one was access to lawyers and legal services. And if you look at your Article 48 is access to justice. Article 49 is, of course, rights of arrested persons. When you've been arrested, you need to make a call to a lawyer, okay? And then Article 50, of course, requires you representation. And if you cannot afford it, then it requires that you be given representation at the expense of the court, and that goes with the Legal Aid Act and the National Legal Aid Council. And then of course it speaks to the people who are qualified to get these lawyers. And of course these are refugees under the Refugee Act, these are children, these are Kenyan citizens, you and me, in the event that things go south. These are stateless persons and victims of human trafficking. And of course it refuses to cater for companies going through liquidation, insolvency, bankrupt persons. It does not cater for NGOs. It does not handle succession property. It does not handle trust corporations, etc. Okay. And then another thing that it wants is that it wants the government, the UN basic principles, the government to ensure there is funding, okay? The government to ensure that there is funding for judicial services. And of course we have the judiciary fund. There's a judiciary fund in place which they get from fines, from bonds, from bails, and the judiciary just has a fund of its own, okay? And then they also want government to form professional association of lawyers, which I've talked about. We have LSK. The purpose is for Article 48, access to justice. We also have Kituo cha Sheria, which deals with matters of access to justice. Of course, it is not under the government per se, but it does that role. And then there are safeguard in criminal matters, which to the government to ensure that the accused is informed. That one we've talked about. And then we've talked about people who should be represented. And then people who've been arrested to be presented to court. Okay, to be presented to court as early as possible. And you know that under Article 49. And then people who are arrested and detained should be visited, okay? And then now they are looking at your qualification, you as a lawyer to represent these people. What is your qualification. Your qualification should meet the requirement of your state. In Kenya, of course, it's Section 9 and Section 12 and 13 of the Advocates Act, where you're supposed to be admitted as an advocate, and your name will be enrolled in the roll of advocates, and you'll be given a practice certificate. But the condition is that you will have to have a degree from a recognized university in Kenya, pupillage, you go to KSL, and if you're from East Africa, then an exam can be administered to you, and then you'll be allowed to practice in Kenya, okay? Then the government is now told to protect you, ensure that there's no discrimination against you on the basis of Article 27, which is race, religion, status, gender, ethnicity, political opinions, national and social origin, birth, health, those grounds. You as a lawyer should not be discriminated under those grounds. Then you're called upon as a lawyer to maintain the honor and dignity of the profession. You're called upon to maintain the honor and dignity of the profession. You're supposed to assist the client to get their legal rights and obligations, okay? And you are supposed to promote the cause of justice. Everything, your end game is justice, okay? And then you respect the interest of your clients, and after that, there are guarantees, okay? There are guarantees. Government should ensure that you perform your functions without intimidation, hindrance, harassment, or improper interference, okay? And when we are talking about lawyers, we are also talking about judicial officers, and we're talking about presiding officers. Just hold on, someone is knocking. Let me call someone. Let me give someone the information. Okay, so sorry about that. Okay, so you'll be given protection. Those of you who remember just the other day, the issue of Honorable Principal Magistrate Kibuti, you could see that there was a lot of intimidation. As this is by the way, I was there. I used to work in that court, so you can imagine what we went through when the gunman was just right next to me. And another one is the Willie Kimani case, who was killed in 2016, the lawyer for IPOA. Okay, so these things, when you think of them, when there's security for you, okay, when there's security of you for you, and you're being protected from intimidation, then we can avoid a lot. You have to be allowed your freedom of expression and association, okay? Sio kukaziwa kila mahali. We have seen that the issue that Nelson Harvey was talking about, the clients of those people who ate the money, and pretended, sold the Sirona Hotel under pretense. They were just gunned down. There was no fair trial. They were judged and condemned, okay? So your government is called upon here to grant you those opportunities, and they are also called upon to have a disciplinary body. And we talked about the Advocates Complaint Commission, and then we talked about the Advocate Disciplinary Tribunal. So those things being there, and you also going through continuous professional development, which is the CPD. Every year you're required to take a test to get 5 units. Those ones, they will be in tandem with the UN basic rules for lawyers, okay? So what are the qualities of a good trial lawyer? You need clarity and order of language. Of course, you need to understand either English or Kiswahili, depending on where you will be based. Then honesty and integrity, chapter 6 of the Constitution, okay? And then you, of course, you respect the other codes of standards, like SOPEC, etc. You need to be objective. You need to be courageous. You need to be alert. You need to be tenacious. Sincerity. You need to be sincere in those. I'm just mentioning them in passing because you just have to think of what is required of you in the profession. You need to be human. You need to work hard. You need to apply professionalism in whatever you are doing. Okay. So what are the general ethical duties of lawyers, okay? If we look at those, we can see the definition of a profession is, of course, a calling requiring specialized knowledge and very long and intensive academic preparations, okay? You must know that the judiciary has a Kenya Judiciary Training School for advocates. It's like for the judiciary, it's like an academy, okay? And then, of course, you have your own CPD test to take, continuous professional development. And then there is the Prosecution Training Institute for Prosecution Counsel. So you see, people keep going through training over and over and over again, and that makes you realize your ethical calling and the continuous need for you to be professional. Okay, so the question, professional ethics also has a question of whether law is a profession or a trade. And of course, for trade, you will talk about it is more of a skilled job, has manual skills, and some specialized training. Okay, but the process that you go through in order to become an advocate is more of a profession. It is not a trade. A trade may involve the use of manual skills, but your professional skills, they make you more of a profession than a trade. Okay, so now we want to look at the advocate's duty to court in regards to, we are approaching recusal. Okay, when you need to say no, I cannot be representing this client because of reason A and reason B. Okay, of course, you have an overriding interest to the court, section 55 of the Advocates Act, and we talked about that. We said you have a duty to correct court, duty of disclosure, duty not to prolong cases. I'll just repeat them as I go. Then you have a duty to disclose conflict of interest. King Woolen Mills, anytime you see that hapa kuna conflict of interest, I've already represented this person in the same case, and now we are on another level, same case, then you declare it immediately. Okay, you declare it immediately. This trial advocacy will ask you about duty to the opposing counsels. I believe by now you know that. And we defined conflict of interest before. Those who are not there, we say this is where your private duties, your private personal duties will conflict with your duty to the public. Okay, they will conflict with your duty to the public. And what are you supposed to do? You're supposed to report immediately and say, hapa there is a conflict of interest, and I don't see myself representing this client objectively. Okay, so what is the difference between ethics, morality, and law? Okay, what is the difference or between ethics? And ethics is just how you're supposed to behave. Okay, these are principles that govern your behavior. Okay, and what is morality? Morality is right or wrong. Morality is right or wrong. However, legal ethics goes in tandem with law because it follows a set of formal rules. It follows a set of formal rules that have been written down and you're supposed to follow. So I'm going to skip your duties because I do not want to keep repeating your duties. Let's look at the cab rank rule. What is the cab rank rule? This is a common law principle, okay? It came from England. And the simplest way of describing it is usually there's a taxis they park in a place called rank. So when the first taxi guy has carried people, then the next in line should carry people. So that is how you're supposed to behave in law. You're supposed to pick the next client. You should not discriminate against them and say, apana, mimi staki huyu client because they do not have enough money or because they look like this. But there should be, sometimes there will be an exception to the cab rank rule. Okay, so what is the exception to the cab rank rule? The advocate may have been consulted by the other side. Okay, or the taking of the case will interfere with some office of some office that the advocate holds or in his duties as an advocate. Okay, let me give an example. If you are a commissioner, say in a tribunal, okay, if you are a commissioner in a tribunal which has the jurisdiction to hear the case, then you're supposed to declare conflict of interest because that outcome may be different from the one in the tribunal. Okay, and sometimes another exception is when you lack the necessary expertise. Say maybe you're dealing with land law and this person comes to you with issues of corporate law. You will have to tell them, we do not deal with that, we strictly deal with this. So you can refer them to another firm. Another exception to the cab rank rule is your schedule is full. Okay, your schedule is full. Okay, another exception, you have confidential information like Zakaria Okotobado versus Wajakoya. Okay, and then you have to declare and say, reason one, I was consulted by the other side already, okay? Two, this might interfere with another tribunal that I'm sitting on that has the jurisdiction to hear a similar case, okay? Another one, I do not have the necessary expertise to conduct the case based on the subject matter. Another one, I have a very busy schedule. I may not deliver to this client, okay? So those are the exceptions to the cab-rank rule. All advocates should attend to a client without discrimination, without turning them down, but there are exceptions, okay? And so we have, what else do we look at? What else do we look at here? We look at, let me just open. How do you declare conflict of interest? Number one, it could be voluntary disqualification, okay? You just disqualify yourself and say, I'm not able to sit here because of this particular matter, those things that I talked about, okay? Number two could be compelled disqualification. Sometimes the opposing client will say, this person had already been instructed by the other party, so we are going to compel this person to disqualify themselves, or they be disqualified by the court, okay? And moving on, when do judicial officers and magistrates experience conflict of interest? When do they do that? They do that in situation where um, it's maybe their company, something they are related to, like their company is the one that's coming to court. So you see, their judgment will be biased. Or if they are individually affected, okay? They're individually affected, like it's their sister coming, their sister is the one, the defendant, the defendant, or even the complainant or the plaintiff. And in some situations, I usually give an example of the cases for the squatters in Malindi, Kilifi, and Lamu. If you were affected as a child growing up, and even maybe presently your parents are still being affected by the issue of squatters taking these you know, land owners, the people that own huge parcels of land to court, then you need to disqualify yourself. And what are the principles? What are the principles that govern judicial officers? Of course, there's judicial independence, okay? Judicial independence is where you are supposed to maintain objectivity, okay? Maintain objectivity. What is another one? What is another principle that you're supposed to abide by? Judicial impartiality. You're supposed to be impartial. You're supposed to be impartial. And if you look at your constitution, you will see Article 10, of course, Article 50 is supposed to be impartial. And then judges also have, they abide by the Bangalore principles of judicial conduct, okay? Bangalore principles of judicial conduct. And these principles are governing these principles are governing the principles that the judicial officer are supposed to abide by. So we've talked about independence, we've talked about impartiality, then there's propriety, being proper, okay? There's propriety, those are three. And then the fourth one is, we've talked about, let me see, independence, propriety, integrity. There is integrity. Of course, that one goes with chapter 6. And then they avoid conflict of interest. There is a time when Philip Moi asked a judge called Karaoke to recuse himself on the grounds that while the judge was the chair of LSK, the judge had had a lot of run-ins with the father, President Moi. So the judge knew a lot about him, okay? So Philip Moi applied for recusal on the grounds that wewe unajua babangu sana, so you're not going to avoid conflict of interest, you're not going to be impartial, you're not going to be proper, you're not going to be neutral, okay? You're not going to make an independent and objective decision on this issue, okay? And what else are we looking at? I'm really trying to go fast so that you remain on your own and you're able to study the legal test and principles applicable to recusal, okay? So what are these principles applicable to recusal, okay? Parties expect their cases to be heard by a fair and independent court, body, or tribunal, okay? They want to see impartiality, they want to see propriety, they want to see integrity, they want to see neutrality, they want to see independence, they want to see all those principles being exercised, okay? But in some cases, these principles will not be exercised because of conflict of interest, okay? And the one example I just gave was the one for Philip Moy and Judge Karaoke. Let's just call him Judge Karaoke. And then there's also another case law for David McCully. David McCully used to be a presenter, a news anchor for Citizen TV, okay? And at some point he made an application for a judge to recast themselves. But when are the situations where judges cannot recast themselves? I'm talking about recasal, okay? And there are these situations, two of them. The doctrine of necessity, okay? The doctrine of necessity. If the court will not be properly constituted, then the doctrine of necessity will be applied. This is usually used, the court does not have any other competent person, okay? The court does not have any other competent person to adjudicate a matter before it. And this is usually, if you look at like the IACA, the economic and corruption, and the economic anti-corruption, the anti-corruption court. Sometimes they don't have a competent person and they need to reach the quorum. So what do? They apply the doctrine of necessity despite the need for recusal, okay? And then the other one is doctrine of the duty to sit. The judge is supposed to sit unless there's a compelling reason not to sit, because it is assumed that this doctrine of duty to sit flows from the Constitution, of course, Article 159 to common law. So judges, they take an oath to serve, okay? They take an oath to serve, and they say they will serve impartially and they will defend and protect the Constitution, okay? So if there's the doctrine, for the doctrine of the duty to sit to apply, for it to apply, then it is assumed that they will rise above their personal opinion and prejudices, and they will uphold the law because they've received enough training in the profession to allow them to separate the two, their personal issues and the law, okay? There was the case of Gladys Bosch Sholai, okay? Where Judge Ibrahim said that the doctrine safeguards the right of a person to be heard and determined before a court of law. Like, if we look at the Constitution, the duty to uphold the Constitution and to give an independent, impartial judgment will allow this judge to sit. So doctrine of necessity and doctrine to sit, they usually are like the same thing, So you may, when you find time, just go through it to, let me take some water, go through it to ensure that you know the difference, okay? Doctrine of necessity and the doctrine of duty to sit. Let's look at something else. And what we are looking at now is court etiquette. Court etiquette. Some of you have done your pupillage already and finished. Some of you are yet to go for your pupillage. This is usually the time. And what is the rationale for dressing? What is the rationale for dressing? When you dress like a lawyer, you exude power and demand a certain level of dignity, okay? So the darker the color, the more authority it commands. If you don't know that, I want you to know that today. People who wear black suits, they really command a lot of power. But if you show up in rainbow, no offense to the rainbow community, if you show up in rainbow colors, there's a way people will look at you and think, huyu ni clown, okay? Huyu ni clown. And for those who've watched the clown, the clown that is the Joker, the one that is the enemy for Batman, you know what I'm saying, okay? So the LSK Code of Conduct prescribe the mode of dressing in public, okay? And your dressing should be in a modest manner that lends itself to the profession, okay? If you do not dress well, if you do not Whatever they say about darkness and berry. Oh, I like that. I like that. So if you do not dress well repeatedly, then it will undermine your standing in the eyes of the public, okay? So the LSK Code of Conduct and Ethics requires that you dress properly. You're supposed to be appropriate. You're supposed to be appropriate, okay? And the word appropriateness is you dressing accordingly. So for female advocates, what do you need? No revealing shirts, tops, or dresses, okay? This is the LSK Code of Conduct and Ethics. No revealing shirts, top, or dresses. I'm thinking do not go showing your cleavage out there, okay? Do not go in transparency. Is it that called what? See-through tops, and you've gone to court and you're going to address the court. Do not wear very short dresses. That the darker the berry, the sweeter the juice. Hey, a non-user, you are so bent on me responding that I have responded. Okay, so do not wear those revealing things. When you braid your hair, let it run to the back, okay? Avoid colored and different shades, deep, like purple, red. Avoid avoid hair color, dyeing your hair. Yeah, blonde, purple. Okay, this is the Kenyan jurisdiction. Then make sure your hair is held back with a hairband. Avoid very screaming nail polish on your fingers. Avoid heels that will make noise in court, okay? For male advocates, dark suits, and you know that when you're wearing a coat or a necktie, you can only remove it with the permission of the presiding judge or magistrate while in court. You don't just remove your coat, okay? If you don't know, if you didn't know, now you know. Your shirts must be dark, and if it is light, like white, it should be a plain color, not flowers, and then you wear a dark coat on top. Do not wear sagging trousers or very tight trousers, those ones called slim fits. Do not reveal tattoos or chain necklace while in court. And then do not wear shoes that show your toes unless you have a medical issue, okay? So the colors you should wear should be black, gray, navy blue, brown, okay? And there's the case of this guy called Sandstorm. Sandstorm, this is a US case. Sandstorm went to court, and while appearing in court, he appeared with without a tie, okay? And so the judge at that time told him, the judge was called Tyson, told him, if you appear before me again without a tie, I will not allow you audience in court. This guy kept coming to court in contempt, with a funny tie. Another time he wore a very long tie that was funny. So he was charged, found to be in contempt of court and charged, okay? And remember when Willie Mutunga, Emeritus Justice Willie Mutunga came in power, he uh, gave the courts discretion of wearing what they want, okay? Of wearing what they want. And you could see like the Court of Appeal, okay? They will wear black gowns or dark colors, and wigs are optional. He gave them the discretion of wearing wigs if they want. But when Emeritus Justice Maraga came back, he imposed the rules on them again. So someone will ask you, does dress matter? Does it affect performance? And the answer is yes, because number one, you must abide by the LSK Code of Professional Conduct and Ethics, okay? You must be graceful and honorable, and it must show in what you're wearing. The general public, they're expecting you to show up in a suit. You've come with a very funny looking attire. They will not even respect you with their money or their documents, okay? So the decision about what judges will wear, of course, I've said Justice Willie Mutunga told them, just agree. Just agree upon what you want. You can discard the weeds, and those who have them can keep them. You can give them as souvenir, or you can hand them to the chief registrar, and you don't have to wear headgears unless you're a kadhi. And then there will be 2 robes for each court. Choose your colors. One can be functional, you can use every day, and the other one ceremonial, the one that you use to attend ceremonies, okay? And what else do we have here? What else do we have here? When you're asked a question about dressing and addressing the court, then those are the answers that you should give, okay? So how do you address the court? Now that we're talking, how do you address the court? Okay. Number one, my lord and my lady, and they have crept back. Emeritus Justice Willie Mutunga had removed them. Okay, but they have come back and they have crept back. So you will use my lord and my lady when, especially when you're giving your submissions in courts. Okay. Now, how do you address a fellow advocate, the opposing advocate? If she is or he is your senior, okay, this is how you will say, may it please you, my lord. Now you're starting, that's your opening address. May it please you, my lord or my lady, depending on the person sitting, with the kind permission of my senior, okay? With the kind permission of my senior, I would like to introduce the quorum. For the state, my name is Ndambuki Ndunge, okay? You're introducing someone who's your senior. And say Miss Evelyn James is on record for the defense. Okay. So if someone is your senior, you start with the court. Okay. May it please you, my lord or my lady. And then with the kind permission of my senior, I would like to introduce the quorum. For the state, if you're the prosecutor, my name is Ndambuki Ndunge. Okay. And Miss Evelyn Kalunda is on record for the defense. If you are the senior, if you are the senior to this person, may it please you, my lord or my lady, okay? I am Ndambuki Ndunge for the state, and Miss Evelyn Kalunda is on record for the defense. So I hope you've understood that if the advocate is your senior, you will seek their kind permission immediately after introducing yourself to the court, after your first line to the court, may it please you, my lord or my lady. Someone asked me the other day, what is the rationale for knowing if someone is your senior or your junior? The moment you're instructed, the moment you're filing these documents in court, the moment after you've done the demand letter and maybe this person has responded, and now you've maybe filed you've filed a plaint, okay, and this person has responded to the plaint, that is the time you do research on the opposing counsel, okay? And now, how do you introduce yourself in subordinate court? What I was saying, can I say junior learned friend? Yeah, you can say that, but you're usually told to avoid humor in court unless it just comes out because naturally it's supposed to be funny. So how do you introduce the one I was saying for me, please you, my lord or my lady, is in High Court, uko juu ukiendelea, High Court and Court of Appeal, okay? So in junior court, this is magistrate court. How do you introduce yourself? May it please you, your honor, okay? With the kind permission of my senior, I'd like to introduce the quorum. I am Nyamwembe Moses for the state, and Aaron Rees is on record for the defense, okay? If you're this person's senior, may it please you, your honor, I am Nyamwembe Moses for the state, and Aaron Rees is on record for the defense. So kama that person is your junior, you do not have to seek their kind permission, okay? So we've talked about dressing and addressing the court. So let's look at when a judicial officer or a judge gives you direction, how do you respond? You agree, most obliged, your honor, okay? Because they give, a presiding officer or a magistrate will tell you, so this is what you're going to do, this is, you respond by saying most obliged, your honor, okay? And this means that you've taken note of the judge's direction. It also shows your respect for the court. How do you disagree with the court? Remain respectful and courteous to the judge, okay? Also, you present your argument to the judge, but never argue with them. Do not say, no, you're wrong. Instead, you can say something like, in my humble submission, or may I hold your honor's attention a little longer as I develop my point, okay? Do not go saying, no, it is wrong. It should not be done like that. And the other day, there was someone on online court proceedings doing that to the judge, and they called out the judge, they read them. And also, when you're making submissions, don't talk at or be rude at the judge. Even if you feel like you've been victimized, there is time for that. You can later seek recourse under the law, okay? So just make submission in a humble but authoritative voice that still maintains your professionalism, your tactics, your strategy as a lawyer, okay? And then use some oratory tone, okay? Oratory is a speaker's tone, like you're preaching. It's preachy, but not so preachy, premised under the law, okay? So your dress, punctuality, introductions, mode of address, okay? Does your owner wish me to proceed? Does my learned friend wish to object? The person who has learned friend, there is an example. And then for subordinate court, your honor, or superior court, my lord, my lady, and your behavior in court. When you're getting in court, you bow. When you're leaving court, you bow. Usisahau, bow slightly just in front of the judge, okay? And if you wish to deliver a message to one of the trial lawyers, stop whispering and moving all around the court. You can write it and pass it, okay? Or you can just enter the courtroom quietly and you sit next to that lawyer, leave it to the person and quietly exist. Just observe the rules of the court the way you would in a classroom. Do not wander, walk around in court like you don't know where to go, okay? And sometimes when you need some clarification from the accused who is in dock, do not just walk to the accused. Request, my lord, or request your honor, may I approach the accused for instructions on that point, okay? When you're addressing the court, do not address the court while seated. Stand, and then finish whatever you're saying. And then when you're done, you sit down, okay? Get the judge's permission before moving to the next stage of the trial. Do not be another presiding officer. Ni kama you're competing, okay? If you've questioned the witness and you're done, you can say no further questions, your honor, okay? No further questions, your honor. Those are some of the things. Humor in court, you're told minimize unless it comes out or it comes out in your writing or when you're speaking, but avoid humor as a rule of thumb. And then let it not look like you're biased. Do not coach witnesses, okay? I want to seek a clarification from you. Were you ever taken through Angry Men, 12 Angry Men? Was anybody taken through 12 Angry Men in your syllabus? I don't know. Najua, as we did Angry Men, we did the case of Mueni.
Yes, we were.
You were taken through Angry Men. Did you do the case of Mueni?
Yes, we
No.
did.
Yeah.
Some people did, some people didn't.
Yes, we did. We all did. It's in the
Yeah, what about Desmond?
We didn't do agreement.
Okay.
Why didn't make you talk about 12 Angry Men you've talked about? I've never heard of that.
Okay. So this is the case. A boy was accused, okay? A boy was accused of killing the father. And the killing took place 10 minutes past midnight at around 12:30 a.m. And the boy is accused to have driven a switchblade into the father's chest, okay? So Angry Man is premised in the American jurisdiction. So what happened is, as a background, the boy had a strained relationship with the father and the father used to beat him severely, okay? So at 15, the boy had been put in reform school for stabbing someone in the arm, okay? And he was fighting. It is not a citation. It is not a citation. Here's what happens in trial advocacy. In third term, you are taught 3 cases, second term or third term. You're taught 3 cases and these are fictional cases, okay? Angry Men is based on, it has a documentary, it has a movie, and it has a stage play. So these are not citations, but they are used in order to teach you, number one, how to be persuasive in court, and number two, it is supposed to teach you the good and bad points for the prosecution and for the state, okay? So it is not a case you will find in jurisdictions that you to me come a president, just so we are clear. So this boy had been in a knife fight, and then he lived in a very poor neighborhood that was prone to crime, okay? So the moment this boy was presented in front of a jury for the first vote, they voted that this boy was guilty. The first vote, okay? So, you know, we have a jury system in the civil system, the inquisitorial system of law. In common law yet we don't have. So this case was being used though, and you will see why it was important. So they lived in a very rough neighborhood, and 3 individuals came forward as witnesses. Number 1 was the man who lived right below them. And this man said he had the boy say, I'm going to kill you. And then he had the body falling. Okay. Then there was a woman who lived right across them. You can see them from the window. This woman said she saw the boy stab the father. Okay. And then the boy himself is saying, no, me, I was at the movie at the time of the father's death. Okay. So it is 2 people, sorry, who came as witnesses. And then the boy now is saying, me, I was at the movies. So when these 12 jurors are given time to go and discuss this case, and then they'll come back now and vote, and then the court can give a judgment, there was one juror. There was one juror. And this juror said, why are you condemning the boy and her? Because they gave their facts, they say, you see, this boy has been raised in a very poor neighborhood and he had a strained relationship with the father. And we have those 2 witnesses. There's that lady and there's that old man who lives right below them. So they voted 11 against 1. And for a jury, for a vote to pass, it has to be everyone voting on the same thing, okay? So juror number 8 is still saying, I'm the only one who's voting against. I'm saying this boy is not guilty. Let's look at the facts of the case, okay? So the first thing that juror number 8 does is juror number 8 has gone and bought a similar knife, because in the court submissions, the counsel for state said that that was a very unique knife and it had only been bought in one shop. The juror goes and buy several knives like that in other shops just to water down the fact that this is not a unique knife. Anybody can have the knife, okay? Then he also asks them, why do you want to condemn the boy and her? Why do you want to condemn him using his past? The fact that he has been in trouble with the law, the fact that he has been arguing with the dad, does not mean that he is guilty. We are only supposed to look at the facts based on what happened that night, 10 past midnight, okay? Another thing he pokes holes at is, you're saying this old man that lives below them had him say, I'm going to kill you, okay? I'm going to kill you. And that by the time, this man said, by the time I walked there, I saw him stabbing. I saw him stabbing the dad and the dad fell down. This man is on he walks with crutches, okay? He walks with crutches. He's an old man. Even when the distance was being calculated, he couldn't have had, I will kill you, and make it from underground, from, he lives below them, to upstairs to see the boy stabbing the dad. The lady opposite them, on the other hand, wears glasses. So the issue was, what were you doing when you saw them? I was looking through the window. When she was looking through the window, there was a train passing. So she and the old man couldn't have had the boy telling the father, I will kill you. And at the same time, this lady wears glasses. For her to wake up, sit up in bed and take the glasses and put them on and see the boy stabbing the father, the calculation wasn't coming through, okay? So now this juror number 8 is looking to poke holes in the witness's statement. He's already bought several knives to show that this knife is not unique in nature. He's done calculations. They're doing even the steps. You can see them in the video, walking and showing. So the old man walked from here to there in what amount of time? In crutches. And so the boy stabbing the dad, that does not make sense. So what are we supposed to learn? What are we supposed to learn from this story? We're supposed to learn the art of persuasion. We're supposed to learn the art of cross-examining, because what is the purpose of cross-examining? The purpose of cross-examining is digging holes in whatever has been presented by witnesses. And what are the tools that this guy applies? What are the tools? Because you can see he was able to sway the minds of the rest through, he recognized that people are just voting because of majority opinion, okay? And now they will endanger the life of this, they will endanger the life of this man. In fact, he asked for a secret ballot, okay? He was willing to disagree with the crowd. He was willing to disagree with the crowd. Those are qualities that you should have, okay? He asked for facts and evidence. He held a discussion, Okay, he did not hold back or attack anyone. By the way, if you find time you watch that, you can see that he was a very calm guy. His demeanor was so calm, and he did not force his opinions on anyone. He was just asking them questions and opening their eyes. Okay, and then he was looking for non-verbal clues. Like there was a time the guy was saying the boy was raised in a rough neighborhood, and then he asked him, so the fact that they have economic challenges means that it should be condemned. And he was asking in a very calm demeanor, okay? So what are the tools that this guy used in order to get the audience, okay? And these tools, they are tools of persuasion, and they're usually achieved through a three-pronged approach, okay? Three-steps approach. Number one, logos. What do you do in logos? You appeal to the reasoning of the audience through building up logical arguments, okay? You cross-examine everyone and tell them, so this, you think this could have happened? You think this could have happened? So that is number one, logos. What is number two? Number two is pathos. Pathos. So what do? You appeal to the emotions of the audience. It sounds like empathy. So I want you to remember pathos, okay? You have used logos for logical. Now you have used pathos for empathy. Let's call it empathy because you are appealing to the emotions of the audience. When he was asked, why are you the only one who is voting not guilty? He said, it is easy to raise a hand and send the boy off to prison without talking about it. And this will affect the boy, okay? So in fact, he said, it is easy to raise your hand and send the boy off to prison without talking about it a little. He didn't make them think he's going to talk for a long time, a little, okay? So that is pathos. I want you to empathize. I'm appealing to your emotions, okay? And then he used ethos. Ethos is the question of credibility. Ethos is your authority. You're making the audience trust you. So what did he do? He had bought knives in several shops to show these people the knife is not unique, okay? He calculated the steps these people, this old man say he had walked to watch the boy stab the father. And then he also came up with the argument of this lady to sit in bed to get glasses and there was a train passing. So none of these people even heard the boy say, I tell the father I'm going to kill you, because you know the noise that a train makes, okay? So the three-pronged approach is logos, pathos, and ethos, okay? And this is found under, persuasion. For you to persuade the court, you have to apply logos, which is logical reasoning. You have to apply pathos, which you move the audience, emotional appeal to the audience. And then ethos, you derive authority, you get authority from the court just by how you present your facts, okay? So the second story we are going to look at, by the way, tunamaliza, is discharging the burden of proof. How do you discharge the burden of proof, okay? Kwa hii story, before we go to the next story, Desmond, kwa hii story, these 12 angry men, number one, this eighth juror number 8, calculated the place where the father was stabbed, the height of the dad, and the height of the boy. The boy could have not reached the father to stab him in that position unless the boy was on top of something, like a stool or on top of the bed, okay? And the witness, of course, they have been watered down. So you see this juror number 8 is discharging the burden of proof. And there's the question of motive. Oh, so you're saying previous juvenile offense. Previous juvenile offense is not a motive. The boy coming from a slum is not a motive, okay? And then the accused, alibi. He had an alibi. He said he was at the cinema. So what are you being taught in these 12 angry men? You're told, if you want to win, the first thing you must do as a defense counsel is to discharge the burden of proof. How do you discharge the burden of proof? You keep digging holes. And when you dig holes while you're in the process, you make sure to apply the three-pronged approach to persuade the court, which is ethos, pathos, and logos, okay? So let's look at Desmond's stories. And when you're looking at Desmond's story, we will also look at Mweny's story. So as a background, Mweni is married to this guy, and they are living in Machakos, and their marriage is not that of. It is not that of that they went to. It's not civil, neither is it Christian marriage that they went to church. It was come we stay. So they came to live together, and as they were living together, Mweni had 3 children, and their husband used to work in Machakos town. Used to come over the weekend, and Mweni says that when we got together, he went home, and here are the photos of him buying wazee sodas, and here are the photos of him saying that he wants me to be his wife, okay? And this guy says, Apana, me, I hired Mweni here as a caretaker. And she came with the 3 children. In fact, I think he denied the children, or he said only one child was this Kitukayo. She came with the children, and so I just felt bad for her. And so I hired her to work here. And she has never been my wife because I want to marry Alice. Alice lives in a nunnery. She was raised by nuns. So the nuns have said you have to do a church wedding. So this guy wants to leave Mweni, according to the statement of Mweni. And Mweni says, I even raised cattle, and I planted on this land, and I've sold the produce. And Mweni is asked whether she has the receipts for the proceeds, and she says, no, I used to turn over all the cash money to this guy, now the man. Okay, so it's back and forth. The guy is saying, I never married Mweni. Mweni is imposing this marriage thing on me. No, me, I'm fresh, I'm single, I want to go and marry Alice. But Mweni, on the other hand, is saying, I even made improvements here. We had children. This is his land, I agree. We've lived here for over 12 years. We have children, kila kitu, kila kitu, kila kitu. So what does trial advocacy ask you? What is it looking for in this particular story? It is looking for good facts for both sides and bad facts for both sides. So what are the good facts for Mweni? Good facts for Mweni are the children, okay? If it is proven by law, of course, DNA at this point, because the guy is denying, despite the fact that his names are on the birth certificate, if it is proven by DNA, then what will happen is that there will be assumed that the fact that she lives on this man's land, there was a presumption of marriage, okay? The fact that she made developments, which this guy is not disputing too, is also a good fact for Mweni. What are the bad facts for Mweni? What are the bad facts for Mweni? The fact that the DNA might reveal that these children do not belong to the guy, okay? Another bad fact is Mweni cannot show any receipt of developing the land, of making money and giving this person, because huyo ni ule wa mzee akikuja nitamwekea ikashi yote kwa mkono. And Mweni is also saying that the book got lost, the book where she used to write the transactions of the land that involved making money for the land, okay? Now, what are the good facts for the husband? In case the DNA test shows his allegations that the kids are not his, then that is a good fact for the husband. Which other fact is a good one for him? The fact that they do not live together. This guy is in Machakos town, and this lady is here. They do not live together. They rarely see each other. And records at work can show that this guy is always in Machakos town and not Machakos rural. What are the bad facts for this guy? Mweni producing pictures, ndio huyo alikuja kwetu akanunulia wazee soda, and the wazee coming as witnesses to say alituambia anataka msichana wetu na anataka kumuoa. Okay, so usually the good facts for prosecution are bad facts for the defense. The good facts for the defense are bad facts for the prosecution, okay? Let me give you the story of Desmond. Desmond is a Kayang boy. So there are 2 sisters. These 2 sisters, they are in the market. And all of a sudden, someone snatches their bag and that person runs. And another old mzee follows the boy who runs and comes up with a boy called Desmond and says this is the thief. And so they take Desmond to the police station. What are the arguments from Desmond's side? This guy who brought Desmond as the thief is enemies with Desmond's uncle, who has been taking care of Desmond. What other argument is there? The argument is that when Desmond was brought, Desmond wasn't sweating or puff, half and puff. Ile umetoka kukimbia. Desmond was so cool, okay? What is another good fact for Desmond? The sister who claims they saw the boy run with a purse is she has an eye problem, and at that time she did not have her eyeglasses with her, and it was about ilikuwa inaenda kwa usiku, it was approaching night time, so she wasn't able to put like a the face on the name. She's not sure whether it's Desmond, okay? What are the bad facts for Desmond that the prosecution is using? They are saying Desmond has ever been involved in a crime, okay? Which of course can be rebutted by saying they should not be judged by their past, wherever they're saying that. They're also saying that Desmond is just a boy who walks around the market, does not have stuff to do, okay? And what was the other argument for them? I think that was the argument, okay? So if you look at Desmond has good facts, which are bad for the prosecution. And the prosecution also has good facts for them, which are bad for Desmond, okay? So those are the good and the bad facts of a case. I do not know if there's anything else that I have not talked about. What haven't I talked about? Can someone tell me if there's something I've not talked about? I've talked about angry men, I've talked about Bangalore principles, I've talked about what is here? I've talked about persuasion. We've talked about dressing and addressing the court. We've talked about duty to court. We've talked about conflict of interest, recusal, and opening and closing statement. Opening and closing statements, I said if it is in high court, if it is in high court, may it please you, my lord or my lady, okay? And if it is in if it's in subordinate courts, then you say your honor. You start with your honor. May it please you, your honor. And then for closing statement, for closing statement, you will say no further questions, your honor. That is one way. That is all, your honor. You can also say something like seeking. We are further seeking the directions of the court on this. There are several ways depending. There are several ways just depending on what matter is at hand. Okay. Oh, someone talked about. Someone, I saw ADR. I saw ADR. Okay, let me just write them down. Okay, let me just write them down. Give me a minute. Let me just write them down so that we go through them, because I want you to remain by yourself and go through your notes. Let me start with the first one. Objection sustained. Objection sustained is when either the defense or the prosecution, one of them is, say the defense is putting up an argument, okay? And the prosecution objects, and usually they object to the form of the question. Because if we look at cross-examination, if we look at examination in itself, cross-examination is to allow the witness to tell their story, narrate this. No, let me scratch that. Examination in chief, the first one, is to allow the witness to tell their story. Most of the time, it is usually uninterrupted. You ask the witness, tell me your name. My name is Jenga, okay? So tell us what happened on the 15th of October. They tell their story, tell their narrative uninterrupted, okay? Then we go to cross-examination. The opposite side takes over for cross-examination. And what do? They want to come and dig holes. They want to come and dig holes in this case. They want to come and disprove whatever you've been trying to put up in order to win in the case. So in this instance, the questions should be on a yes or no format, okay? The question should be a yes or no format, and they're called leading questions. So sometimes the form that this counsel has put the question through will not be the form required, because if for cross-examination, I'm going to ask you, so you went to the hospital, you're supposed to say yes or no, okay? So the form that they're asking that questions looks like the one for examination in chief. So what will I come and do as the person who conducted the examination in chief? I'll come and say, objection, your honor, okay? Or objection to the form. And then if the court agrees with you, they will say objection sustained. If the court disagree, they will say objection overruled, okay? They will say objection overruled. So number one, something that you need to know, Evidence Act, Section 146 to Section 151 is about examinations, okay? So we start with the it's usually the prosecution. If it's in criminal, the prosecution is the one that starts their case. The prosecution will bring their witnesses, and witness one is usually the complainant or the victim. Okay, in their absence, the complainant could be a parent, a guardian, evil. So this person, prosecution anataka tuonyeshe vile alikuumiza. Okay, so they will do examination in chief. Defense is taking notes and saying, oh, hapa amefanya hivi, hapa naona nitadunga, I'll poke a hole here. Okay, so when the examination in chief clears on the prosecution side, the prosecutor will say, no further questions, Your Honor. Okay, no further questions, Your Honor. And then now the defense will rise to poke holes. When they are poking holes, that is what is called cross-examination. And the rule is to ask open-ended questions or leading questions, okay? Not open-ended questions. The rule is to ask leading questions, okay? These leading questions will take the format of yes or no, except maybe for their name, because you will ask them to state their name, okay? So yes or no, yes or no. So if they are being asked these questions without the format of yes or no, ule prosecutor atasema objection. If the court agrees with the objection and sees hii ilikuwa na shida, they will sustain it. If the court thinks there is no problem, they will overrule the objection. So what happens after this prosecutor has poked holes into this case? What happens is the defense has poked holes in the case. The prosecutor that did the examination in chief will come back to restore what has been lost during cross-examination, okay? I hope that we are clear up to there. Re-exam is the one to restore what was lost during cross-examination. And when the prosecution finishes their case, it will go to the defense. The defense calling their witnesses will be called examination in chief. The prosecution poking holes in the defense case will be called cross-examination. If the defense objects to the way the prosecutor is asking questions, they will say objection, Your Honor. If the court agrees, the court will sustain to the objection. And sometimes the court can give further directions, like ask along the lines of cross-examinations, follow the rules. If the court does not agree, then what will it do? It will overrule, okay? I hope that one is understood. I'm trying to see the other question. The other question is case team and case theory, and you want me to talk about expert witnesses. Now, what are expert witnesses? Today, if you go to criminal courts, Makadara, expert witnesses are listened to every Wednesday. If you go to Kibera, I think it's every Friday. Someone mute your mic, please. Someone mute your mic. So who are expert witnesses? These are witnesses other than those who occasioned the event that happened, okay? They come in after, okay? This could be a doctor. In the case of an issue of sexual offense, it will be a doctor who will examine the patient, okay? In the case of a letter that was written by someone, this will be a handwriting expert. In the case kama hiyo ya the boy, 12 angry men, that stabbed the father, we will look at the position. Maybe someone was called who's dealt with this, okay? In the case of Kama Sharon Otieno, who was murdered, they looked at how many times this person was stabbed and how many people could have been there. They look at things like footsteps, they go to the scene and they relive what could have happened. For those who have watched CSI, for those who've watched those, those series, you know what expert witnesses do. And we also have profilers. They just say this person could have been standing here and the other one was standing in this direction. In Kenya, it's not that deep. But let's start with doctors. Doctors are expert witness. Let's look at ballistic experts. Those are ones who deal with guns. And mute your mic. They deal with things like guns. They will say, hapa walitumia, this is a particular type of gun that was used here. Ini seska, ini nini. Then someone asked about skeleton argument. This is a written summary of your the point a party intends to make in a legal case, okay? So it is usually prepared before a hearing, okay? So if you go for pretrial conference, you have your skeleton arguments already, okay? So what do you say? You say this is what we intend to. We intend to argue. This is what we intend to say, and sometimes you might even send them electronically or drop them at the registry. This is the argument that we want to put forth, because especially in civil cases, because we want you to answer to this, okay? We want you to answer to this. Another one asked about case theme and case theory, okay? So case theme, for case theme, it's usually like a name, okay? In these 12 Angry Men, I can give it, here are the titles. I can give it, no one should be condemned unheard, okay? I can give it, the right to fair trial, okay? In the case of Mweni, I can say presumption of marriage, or you can say something like customary marriage. So case theme is the name. Case theme is the name. What is the case talking about? Without me even starting to read the case, child maintenance, I will know that is the case theme, okay? But a case theory is an analysis of the facts in case in a relation to the law, okay? So for case theory, you will connect the facts and the law, okay? You will connect the facts and the law. The fact that, who should I give an example with? I'm thinking between Mweni. I'm thinking between Mweni, Desmond, the boy, and the boy in 12 Hungry Men. For a case theme, what you're trying to do is you're coming up with several, sorry, for a case theory, you're coming up with several points at the same time. It's like an outline. It's like an outline. You're saying the fact that Mweni had babies with this man, and Mweni lived in this man's land, and this man bought this land in 1989, and Mweni moved in mid 1989, means that this man sought Mweni's hand in marriage. And then this man went to Mweni's home, and you see these photos here, these pictures are of the wazee taking soda and sitting in a kasako sipping something and saying, msichana wetu amechukuliwa, okay? And the fact that they have 3 babies and Mweni has improved this land, and Mweni has been assisting this man in the matters of the land, then that is a case theory, okay? You're coming with a theory that will lead the court to believe that this, whatever Mweni and this guy had was a marriage. There is a rebuttable presumption of marriage. Let me look at something else. I've addressed objections. I'm coming to ADR. For examination, we've said there is main exam, there is cross-examinations. The main exam is called examination in chief. Then there's cross-examination and re-exam, or dimensions and psychology of advocates, case brief and case analysis. Case brief is a dissection of a judicial opinion. Umetoka kusikia kesi, and then now the client tell you, can you tell me what happened? Okay, so case brief could be using FIRAC, of course. You will even include things like the procedural facts, because it could be at the appeal or second appeal level, okay? So what you're doing, you're telling them where the case started, the origin of the case, which is facts, and then you can go to issues. What were the issues in the case? And then you can talk about, when you're talking about facts, you can talk about, hey, please mute and text instead. You can talk, who is it? Who is that? Can someone see who's talking? We call them out.
It might not come directly as what are the points about
I can't even see who it is. Can someone tell me who it is? Write me the name.
Yes.
Who is it? Who is
Linus
it?
KK.
Linus.
Linus.
Linus, please mute your microphone. Does someone have his number?
Linus.
Yeah.
Linus.
Whoever have their
Yes,
number,
can I
tell them
can I
to.
call Wachira or Ruru from Citizen?
Royal Media Services.
That is Linus who?
Yeah.
Linus Kaikai.
Linus Kaikai.
Nobody has his number. Let me tell Sonia to mute Linus.
Again to the court, to your colleague.
Oh, very nice, Mwalimu. He has done it.
How are you?
My apologies, Mwalimu. So sorry. My apologies.
How are you doing?
I'm doing fine, thank you. So sorry.
Okay.
Okay.
I was texting for you to be muted, but it's okay because we are on
Sorry.
the right track now.
Yeah.
It's okay. It's all good. So where was I, guys? Where was I? Oh, so I've
You are
seen.
explaining the issue of Iraq.
I think case. Yeah. So case brief is a dissection of the judicial opinion. Okay? So nimekuja kwako nimekuambia mimi hapa wamesema mimi nitalipa ule compensation ama they've ordered specific performance. Mimi ni mama mboga, I don't even know what that is. Now you able tell me in layman terms walikuwa nasema nini? So what do? You do FIRAC format, okay? You do the facts. And now if you're doing the facts, note the level, the procedural level of the case. Kama mko appellate stage, I want you to point out that mlienda court of first instance. In fact, maybe you even started with ADR. You started with the mediation or arbitration, and then it didn't work out, and so you guys went at Mwalimu. You have been Star Trek. Yes, I have, because I used to see him in UN, and then I was like, I know you, I watch you, and lafu sina la kusema. Awe Musa una siri Musa. Anyway, so you talk about the stages the case has gone through. You talk about the facts of the case, okay? You talk about the issues. What are the issues for determination, okay? And then you talk about the rule of law. You try to explain to them slowly. And why did the court rely on that rule of law, okay? Ratio decidendi, okay? How does it apply? Why did the court use it? Alafu, after that, after your rule of law, what do? We go to analysis. So you analyze properly. Now, what happens in analysis? In analysis, you usually merge the issues, facts, and the rule. Because this happened, the court decided this. Because this happened, the court decided this. And then you can do a conclusion, okay? So umefanya FIRAC vizuri sana. Umeambia mimi mama mboga, you've told me why you think I lost, okay? And it is parties who lose who love case briefs, okay? And then when that happens, the client can also say anataka case analysis, or your boss at work, okay? Or your peer, and as I say, maybe give me a case analysis of that, because we are going to the second appellate stage, and I don't know what to do. Ebuso, give me a case analysis. Ama wewe people ndio unapatiwa hiyo kazi. You know how pupillage works. So if you're given that brief, if you're given that brief, or even if you're just given the case itself and you're told to do a case analysis, here is what you will do. Do not accept decisions blindly. You do a case brief, vizuri sana. Case brief, you follow FIRAC. In your conclusion, in your analysis, you say why something shouldn't have happened the way it happened, okay? This is it. You're saying, Apa, the learned judge erred by applying this law. Maybe ange apply the other law, okay? It could have worked better. Like in a situation in criminal law where you're supposed to be acquitted under 87A. 87A is usually what? If we get more evidence, we are acquitting you for lack of evidence. But if we get more evidence, we can arrest you on the same charges, okay? But is it to 10 acquittal? Hiyo inakuanga, if you're brought here again, then you can say atro for convict, or atro for convict, acquit or convict, like double jeopardy. Siwezi letwa tena hapa na hii kesi. So in the event that your client has been acquitted under 87A, you do a case analysis and tell them, the court should have acquitted you under section 210 of the criminal Criminal Procedure Code, okay? So your argument here is we are not accepting any decisions blindly. We are going to even give an analysis to show what will happen if we go to the appellate stage. I hope that I have answered that. I want us to look at something else. I hope you're still writing questions because now we are clearing ndio nikuache usome peke yako, okay? So what is appellate advocacy? Appellate comes from the word appeal. Anytime you go to an appeal court, anytime you go to the appellate stage to represent a client, okay, or a party, then that is appellate advocacy. What do you do? Number one, you have to do either a case brief or a case analysis on an individual level or for the client, okay? So what do? You want them to reverse the decision. You want to tell them why your decision was not the one you should have taken. You want to win at this stage because you lost in the previous stage. I cannot explain this any further. It is as simple as that. What else is being asked here? I've talked about examination in chief. I'll finish with ADR. I hope objections iko poa. Impeaching a witness. Impeaching a witness. We have two types of witnesses, okay? Usually, we have a refractory, Sindo. We have a refractory witness, and the other one that we have is a hostile witness, okay? And then we also have, let's just start with impeaching a witness. Usually, you impeach a witness by telling the court, this person is not being truthful. How is it done? It is done by cross-examination, okay? Because some witnesses just come to court. Mimi niliona akimpiga, but they didn't see anything. So what do you do to this witness to impeach them? Number one, inakwanga cross-examination. Number two, before you get to the court procedure for the hearing or whatever it is that you're going for that day, you can make an application to court. Okay? You make an application to court under a certificate of urgency, or just sometimes you just go by notice of motion. You make an application to impeach the witness because you have gathered evidence, because you have to show that this person is not being truthful. They shouldn't even be witnesses. They do not qualify to be witnesses, okay? Then let's look at a hostile witness. What is a hostile witness? This is someone, all of a sudden, they've just changed and they are not talking to the party who called them. They are not talking for the party who called them, because the idea was to come and enrich that party's case. But all of a sudden, amegeuka. And let me tell you where you will meet these issues of hostile witness. I saw another one saying, this is the shemeji to the lady who was, it was an issue of wife, what will you call it? Let's call it assault. It was assault. Ilikuwa story assault. Amenyoroshwa. The sister has come to say alimpiga, alimkanyagia, alimvuta hapo kwa nyumba nikiona. That was the statement that this person gave the police, the witness, okay? So they get to court and they've been bribed. They've been told, huyu msichana wenyu nitamfukuza na sitalipia watoto school fees. Tuone hiyo koti kama itawalipia school fees. So when they get to court, they become witness. What do you do to this witness? This witness, you subject them to cross-examination, okay? You subject them to cross-examination. The idea is to maliza them in court. Unawauliza maswali uongenye anasema it can be seen, okay? The court can see it right through the lies, okay? And then you get rid of them. Si wamemaliza part yao wenye they were to come as witnesses. Mambo yao imeisha. So you kiwa it by cross-examining them, because of course you will establish the truth or the lie. And then there's a refractory witness, and this is a person who refuses to cooperate kabisa. Amekataa to provide any evidence. They have refused to be sworn in. They have refused to answer questions. They have refused to produce documents, and they have refused, sometimes if they are needed to sign, they have refused. So what do? You adjourn the case for up to 8 days. In the meantime, you take them to prison. You commit them for 8 days, okay? You bring them back. Amekataa tena. They have refused to speak. They have refused to be sworn in. They have refused to answer questions. They have refused to produce documents. They are refusing to sign a disposition. Commit them again. So it's really a funny process, because If you've seen someone being committed, it's really funny. In your head, unasemanga, si huyo aongee tu story ishe, okay? But some of these people, they have nothing to lose, okay? Why do we say we have two witnesses? We forget the witness that is cooperating. I didn't get your question. I didn't get your question at all, at all. I want you to just tell me kama hiyo question ulikuwa unauliza kwa njia nyingine, okay? Just, you can try and reframe it and ask it again. I have answered everything so far in except for ADR. Na hiyo yenye I need some clarification. Now, let's look at ADR. ADR is alternative dispute resolution, okay? And you guys, by the way, watch out for those trainings that are provided for ADR. You become a certified mediator even before you are admitted, okay? So usually, under ADR comes from Article 159, 3 of the Constitution, okay? Which asks for alternative dispute resolution measures to be applied. And this one is usually under, is it basic structure doctrine? It's, let me just confirm, basic structure doctrine. It's usually there where you're told, Ebu is this dispute that is there, just try, it is not basic structure, it's the other one. Try and solve them. Try and solve them from the beginning. You see, the time you're writing a demand letter, after that demand letter, you can get into ADR, okay? The moment you get into ADR, what will happen? Litigation is time consuming. Going to court is time consuming. So if you do alternative dispute resolution, you will save time. What is the one way of saving time and ADR? You sit down for mediation, okay? So for mediation, when you sit down, both parties present their cases. And then you, if you are the mediator, you tell them who you are, they present their cases, you hear from both sides, and then together you help them come up with an outcome that is beneficial for both parties. What do? Someone has to give something. Inakuanga give and take, okay? Someone has to give something, but hakutakuwa na forceful, like taking from someone or orders. It will be, you're listening to both sides, and then you kind of guide them. You're the guide. You tell them, na wewe unaona kama hivi vile anasema wewe hausaidii mtoto, unaona kama unaweza afford tukiestablish mtoto ni wako. Then the kamze says, hey, tukienda DNA waseme huyu mtoto ni wangu, mimi I will provide for this child, okay? Alafu huyu naye anaambiwa, huyu mzee anasema hiyo pesa unaitisha ya school fees na upkeep ni nyingi sana, unaona kama unaweza revise. And then this person will say, okay, yeah, I think we can revise that, kwa sababu sasa kama amekubali kuangalia mtoto, then that changes everything. And I think mimi niko tayari kukaa na yeye tuamue mtoto anaweza patiwa pesa ngapi in a month, okay? Then we have another form of ADR. What is the other form of ADR? Conciliation, okay? And what is conciliation? A lot of us think that Vile Kofi Annan came to Kenya early 2008 because of the 2007-2008 election disputes. Alikuja, wengine wanasema negotiation. Of course, negotiation took place. Wengine wanasema ni mediation. Of course, there was mediation, but the real name for whatever happened was conciliation, okay? So what is the difference? What is the difference? Who sent Kofi Annan? Okay, it's a body, alitumwa na body, alitumwa na UN, sawa sawa. So they resolved the dispute, and in the end, they signed the accord, okay? They signed the accord. What is arbitration? Arbitration is almost, it's closer to the law. It's closer to the law. Litigation. Litigation ni yenye unasomea, okay? And then at some point, unaweza pata uko na umeenda through arbitration, ama umeenda through mediation, or ADR in its entirety. So arbitration is where you two parties will submit your dispute. You'll take it to an arbitrator. The judge, don't call them judge, but the person who presides over arbitration, anaitwa arbitrator, okay? So what do? You decide, sisi hatuendi kotini, hii mambo yetu, we are going to sit in front of an arbitrator. And what are the qualifications of an arbitrator? These people are usually retired judges, okay? They're usually retired presiding officers. They are people they have what is it called? They have experience in law, okay? So what will they give you? They will give you something called an arbitration award. And I want you to know that an arbitration award is final. The award is final. It can only be subject to, in some instances, to maybe to come appeal, okay? But negotiation, conciliation, negotiation and mediation. If the parties fail to agree, okay? If the parties fail to agree, they will go to court and start afresh. But for arbitration, they are final and binding. And in fact, that appeal, it's very limited. There's very limited ground for an appeal, because what does the law consider? If this person is a retired judge or a retired presiding officer or a retired magistrate, just use presiding officer, then this person is well versed in matters of law, and they've attempted to do this privately outside of litigation. So it means they've looked at what the law has to offer and what ADR has to offer. And so there's very limited ground, because these people are never wrong for the most part. They are never wrong for the most part. I'm trying to see if I can now understand your question. Why do we say we have two witnesses? We forget the witness that is cooperating. When did people say that? When did people say that? Let me do dimensions and psychology, contempt of court, and then we call it a day. Patrick, Gadenga, I am sure I did not understand your question. If someone else understood it, they will answer after contempt of court. Na sikulengi, mimi sijaelewa hiyo story yako inasema nini, okay? So what are the dimensions in psychology? Dimensions, rules, and psychology of advocacy. Number one, first trial. Number one, unafaa ujue under dimensions. First trial is usually just an exercise to discover the truth, okay? It's more of a research, okay? It is more than a research. And then how you present yourself to that court, how you present yourself will really set the pace for that trial, okay? Hiyo ni psychology unafaa ujue. So ukiingia hapo with those suits that we refused, the rainbow suits, then say, you will not blame anyone, okay? Then the second, human, animal, more audio than video, okay? What I'm saying here is first impression too. When you come and I see you, okay? When you come and I see you, that is how I will remember you, because ni kama video. I've seen somewhere someone say, a picture tells 1,000 words. No. So before even you address that court, before you talk, I want you to know that people will record vile unaka, vile ulijiintroduce kwa hiyo court, okay? Did you say, may it please you, my lady or my lord? In magistrate court, did you say, may it please you, your honor? Did you recognize the senior with the kind permission of my senior, okay? Did you take directions from the court in a respectful manner? Most obliged, Your Honor. Did you finish your examinations, whatever it is you are doing, and then no further questions, Your Honor? Those things that you do to the court will always remember. And then the rules are never express your own opinion in court. Do not start saying, I think, I believe. And some of your course conveners, I believe, were discouraging you, saying, I think, I believe, I feel like. You feel like what? You go straight to whatever you want to say, okay? You can say the Constitution under article nini ama chapter. Just go direct. Do not add these additions. In fact, these additions, they give rise to unnecessary repetition and long-windedness, which we will look at in our LWD, okay? And then never appear like you're giving evidence yourself. Wewe ndio ulikuwa kwa hii kesi. No, you're just the advocate. You're supposed to advance the agenda of your client, but you're not supposed to appear like, sasa wewe ulipewa story, sasa wewe ndio stero, your moment to shine, okay? And then Submit only on what was touched on evidence. If you have to submit, of course, we said you make court submissions, and that's a legal opinion. You make it to move the court. Tell the court why they should pick you. Tell the court why they should pick you, and then never refer to a criminal record of someone. Si anajulikana hapa, si anaibaiba hapa kwa barabara. No, do not do that. Just stick by whatever is being said in court. Kama hiyo story ya Desmond, okay? Yeah, Desmond, and then do not give offers of settlement in court if you've not been asked by the court. I've seen presiding officers ask, do you people want to go through ADR? And then they will offer. And then the advocate will say, we will look into it. I will sit down with my client, and if my client agrees, I will approach the opposing counsel for his client's opinion on the same, and then we can go through ADR, because cases zingine there, it's a waste of time dragging them in court. You know how litigation goes. Unaweza patiwa next hearing date ya sahi, we are in November. You can be given a next hearing date for, say, next year June. Na hakuna kitu tutafanya. That's the diary of the court. All right. And what else before I go to contempt of court? Do not testify from the bar, of course. Yeah. Wachia witnesses wafanye kazi zao. And then the psychology of advocacy, be likable. Then sympathy rules, try and evoke sympathy from these people. And then rules of equals and opposites. Do not intimidate your juniors by making demands, okay? Make requests, make suggestions, okay? Then try and use first person plural. We humbly submit, okay? We would like to await the court's direction on this or on the same, okay? And then always prepare. Your opening statement is what will make or break you sometimes. It can break the case. Mtu atakuangalia tu aseme, huyo alipatiwa hii kesi pale kwa barabara na amekimbia ameingia tu hapa ndani. You can always tell, okay? And then be an honest guide. Do not mislead the court. Do not misquote evidence. Do not misquote evidence. Work within the confines of law. Then try to have minimal objections. Si kila sasa you're excited. Objection, Your Honor. Objection, my lord. Apana. Make sure that it is justified, okay? And even for it to be sustained, it has to be justified. So you'll be making objections. Unaambiwa overruled kila saa. Doesn't make sense, does it? Okay? And then demonstrate competence. Know your law. My friend, if there's something on the day of submission you should do, on the eve of submission, you should be ready. You should have a shortcut in case you're running out of time and maybe you have to go attend to another case or hearing in another court. You should just know your law. You should have 3 ways of doing it: the long way, the medium way, and the short way, okay? Because things change sometimes when you get to court. And then be a good listener. Be a good listener. It is a skill that you have to learn. You have to learn to listen. You have to sometimes show that you're listening by nodding, okay? That is one way of just showing you have my attention, okay? Avoid repetition. Avoid repetition. I'm saying that while I'm repeating myself. Use sparingly, and then show the way home. When all is said and done, the end game ni nini? You just want to show us the way home. You want to show us why the court should decide that, why the court should decide that your submission is the way to go, or whatever you've done from the beginning to the end of the case. So let's look at